Okay, yeah, we're gonna go ahead and get started. Thank you everyone for joining us, especially everyone who is able to beat the traffic and make it here in person. I really appreciate you coming out and making the effort to join us. Um, for those of you who are visiting us online, I understand that it's so much easier to join in Zoom. Logan, our PAA board president, I were just having a conversation about the difficulty and how we have all kind of gotten used to online presentations and the ease of that. But there's something lost in that. I feel like it's really important to have these in-person connections and have these conversations. I think it can really help with advancing careers, especially for our younger arborists, and for establishing those connections long term. So I really appreciate everyone who is able to join us. And for those of you who are attending virtually, I hope you're able to gain something from this presentation and that you can join us sometime in the future for some sort of networking opportunity or in-person event. Speaking of in-person events, speaking of events, our next webinar will actually be a webinar. It will be online via Zoom as our usual programming. It is going to be a utility arborist topic with Georgia Power. So hopefully I'll have that information sent out to our membership database within the next couple of weeks. We do have a wildfire risk reduction qualification course coming up. That's going to be in Macon in July. We also have a tree and plant appraisal qualification course coming up in July. And then our summer symposium, which is one of GAA's historic events, is going to be in August. It's going to be in Griffin, and it's going to be, the topic is going to be on storm preparation. So it's going to be geared toward the production arborists and how to prepare for the upcoming storm season. So exciting things to look out for. We also have finally secured a location for our tree climbing competition. Very exciting. It's going to be here in Cobb County at in Lithia Springs at Violet S. Stout Park. It's a beautiful park, and we're very excited to host our 27th annual tree climbing championship. So I hope you'll all be on the lookout for that as well. So lots of exciting things coming down the line. As always, I am here to help you in your arborist career and in any way that I can support you. So I hope if you have questions, comments, concerns, anything that I can help you with, please do not hesitate to reach out to me. If I don't know the answer, we have a vast network of arborists that can help, and I'm happy to make those connections if I can. So please do not hesitate to reach out to me if there's topics that you're interested in learning about. Speakers that you would like to see present, or any kind of opportunity that I can assist with. That's what I'm here for. So please reach out to me if you need that. Your membership benefits are really important things to utilize too, not just for attending CEU events, but also these networking opportunities. You are part of a larger organization as being a member, and so take full advantage of that. So we really appreciate you being a member. With that, I'm going to introduce our speakers for this evening. The topic for tonight is Trees and the Law 3.0. If you missed the first two presentations, they are available on our YouTube account, so you can go back and review them. They are different topics, and you don't have to have viewed them in order to attend this one, so don't worry if you've missed that. But they are available on our YouTube account. For our virtual attendees, there is a CEU for this event. I will post it in the chat for the virtual attendees, and it will be there will be a QR code at the end on the screen for everyone in person. And I think that's all the housekeeping I have. So without further ado, I would like to introduce Lee Clark and Kay Ivanovich. Lee is with the Georgia Forestry Commission and Kay is with the City of Decatur. And take it away. Go ahead. My clicker isn't working, so you're going to have to.
Oh, okay.
It was working. I don't know why.
Sure was.
Okay. Hi, everybody. Thank you for being here. We're going to split the presentation, and it's about obviously being an expert witness as both a private arborist, which I'm going to cover, and then as a municipal arborist, which Kay has experience with that she's going to cover. Oh, we're going to ask that this topic typically generates a lot of questions and a lot of discussion. And since we're trying to get through it in a limited amount of time, if we could hold all the questions to the end, we would appreciate that. And you're right, the clicker's not working.
I tried.
This one isn't either.
Oh, yeah, I did so much to get this ready.
I like the little pop noise.
Very much.
You have to do it. Oh, okay.
We gotta put it at work.
It was working. I don't.
Ah, I got it. It's working now. Okay. Well, not the clicker, but.
Yeah, the clicker is working.
Oh, all right. We are functional. Oh, okay. All right, this is me. That's all my qualifications. Y'all have seen me. Sydney. And it's not, this is not legal advice. We're just telling you stuff.
Yeah, and this is me, you know, actually, you got a picture, yeah, there it is. ISA certified arborist and landscape design is certificate for memory. Also a Georgia Soil and Water Conservation Commission level 1 trainer, so I do erosion control stuff as well. And then I was chief of environmental inspections for DeKalb from 1999 to 2009. I had to go through the police academy with them for enforcement procedures, which is something that you go through when you are a sworn officer for an entity like a municipal agriculture. Municipality or government entity, something like that. So, and again, this is not legal advice. This is just information about how this works.
Jesse, do the people online, are they seeing the slide or are they seeing this with me in the way?
Us with this.
They're seeing the top one? Okay, so I need to get out of the way.
There's no slide. They see the whole screen and you as a little dot.
But they can't see this otherwise, right? Or they can.
They can. So I'm sharing the screen, so they see the screen.
Okay.
And they're also seeing you, but very small.
This is what they're seeing.
Thank you.
Okay.
Okay, so this is what we're gonna cover, is who is suing whom when it's a private situation. It's gonna be neighbor versus neighbor. What, did I do something?
Yeah, you went forward. There you go.
Oh, there. Who is suing whom? If it's private, it's gonna be neighbor versus neighbor, or landlord with the injured tenant, or something like that. So it's gonna be person versus person, or even a company, corporation. On the municipal side, it's gonna be who gets a ticket.
It's a ticket, basically. It's a violation of ordinance. If you're a state enforcer, it would be a violation of state law, state code, things like that.
So if you are private, you gotta figure out who hires you. Do you get hired by the attorney for, you know, whoever, whatever side's calling you, plaintiff or defense? Or do you get hired by the lawyer or by the client himself or herself? Who do you want to be hired by? And then what specifically are you being hired to do? So this is just what we're gonna go through. Then the second topic is forming your professional opinion. We go through the documentation that you need to do, chain of evidence, custody issues, enforcement as a municipal arborist on serving the tickets, and then the different types of testimony that you're gonna encounter as an expert witness. So in private, again, it's gonna be person versus person, and they'll be suing over negligence. You I didn't touch that. Y'all saw, I did not touch that.
Sorry, you didn't touch it.
Okay, technology does not love me. Okay, so reasons that people sue each other over tree incidents is going to be negligence is the most common cause of action, the most common thing that someone will sue somebody for. You had a duty to keep that tree safe. You breached that duty because you didn't keep it safe. That caused me damages or money or injury, and so I'm going to sue you over it.
And on the municipal side, you have basically a criminal case that could be that for state law violations.
This is like a parking ticket.
Yeah, you could just like you get a parking enforcement ticket, you can get a code enforcement ticket, you can get a ticket for violating a tree ordinance. Erosion control ordinances for the state, for the county, you can get tickets for that as well. And you may ask, why would a government entity cite its own landowner? Well, there's an issue of liability. If there is a dangerous tree or something like that, it could fall on the street or sidewalk, and you let the homeowner know who owns the tree that exists, and they fail to do anything. So it's part of protecting the public is what they issue that for. And then, of course, it's also public safety. It's a public safety issue. Even first and foremost, for any government entity is looking at public safety.
So does the lawyer, the lawyer, does the lawyer hire you or the client hire you? Well, where are you gonna get the more secure payment arrangements? Who's
Then
gonna
it's just
sign
good.
it? Did it do it
Yeah,
again?
did it again.
See, I didn't touch it.
That's okay. I'll stand over here with it.
Okay, here it is. Okay, the more secure payment arrangements are gonna be with an attorney, not with the client. They will sign a contract with you. It's a good idea if you, as the expert witness that's being hired, present your own contract. And there's lots of templates online. You can cobble them together. And I would love to walk you through one of those contracts, but that would be like treason law 4.0. So you want the lawyer to hire you. It's much more secure. You're going to have a contract and you have recourse if you don't get paid. So yeah, your contract should cover all of that, definitely payment, who pays taxes? Are you an independent contractor or an employee? Who pays insurance, like workers' comp? Do you have anybody else working with you, like any subcontractors? If so, who pays their taxes and employment taxes and all of that kind of stuff that you gotta pay? And then scope of work, you've got to cover scope of work in your contract. What are you being hired to do specifically? And get all of that very specifically in there.
Yep, and you want to know, do they want you to be an expert witness? What all are you going to have to testify to? What are your credentials? You'll need to present all that, that kind of thing, so.
And you can charge different amounts there's really three kinds of testimony that you would give. You can, deposition testimony, you can charge a certain rate for that. You can charge for your investigation, going out and looking at the scene if there is a scene to look at, and then pictures, and then compiling your written report. That can be a charge at a different rate if you want it to be. And then trial is going to be, you can charge the highest for trial, because that's important time. And all the experts charge more for trial. For that.
Yeah, for expert witnesses. Oh, where to go this time?
No, that's okay.
That it?
Yeah.
Okay, good.
So I'm talking way too much. but
No,
you've
you're
got
not. You're fine.
Okay.
Oh, did you
your-
do it? I didn't do it that time either. You must have this on a timer. Okay, it doesn't matter. We got it.
Probably is.
Yep.
Okay. So your scope of work, you want this in the contract. You're going to investigate. Hopefully there is a scene that you can still investigate. If not, then they're going to have to show you pictures, or you're going to have to talk to people, or get whatever evidence that you can any way that you can. You
Yeah.
document your opinion, you analyze all of that, and then you form a professional opinion. And as an expert witness, the definitions of expert witness, they come from, in Georgia, both case law and statutory law. And it said both the statutes and the cases say that you can be qualified as an expert witness by either your education or your skill or your experience or your training. You don't have to have a certain degree. You don't have to have certain anything. It's just who you are and what you present with. And a lot of it is your experience. If you've been on the job for a long time. Okay, so yeah, you can, if you observe the facts in person and you take your own pictures and you do all that, then it just went blank. Okay, then they are gonna ask you about what you saw, and you will have to document that and show pictures and reports and your methods of documentation. If there is no scene to go to because it's already been cleaned up or there's just nothing to see, then you'll have to do it the hard way. Either, find your own evidence, look at pictures, talk to people, do what you can. And then at trial, the questions will be entirely hypothetical. They'll construct if you were to see a tree that has these characteristics, what would that indicate to you? Since you can see the actual tree that fell. And then if you do this investigation, you form your opinion. Oops, what if your opinion doesn't help them? What if it actually hurts them? Do they still have to pay you? Are they still going to hire you? Yes, they still have to pay you if you wrote your contract correctly. You're still hired because you still have the contract and they owe you money. They might not want you to testify, and they might not even tell the other side that they hired you to come up with this opinion. If they don't like the opinion, then they just keep it secret. They don't have to disclose it to the other side. They don't have to get you to testify. They just keep hiring people until they get the opinion that they want. But we're arborists, we're certified arborists, and so we're all gonna come up with pretty close to the same opinions. Can you offer that opinion to the other side? If it helps the other side more than it helps your side? No, you cannot. You can't even tell them that you were hired to give an opinion. It's all confidential. Don't do any of that.
All right. So, informing your opinion. Your professional opinion is based on documentation. At least it has been for most of my career. Doggone it. Okay, stop it. All right. Like I said, you've got to keep your pictures. Photographs are worth 1,000 words in any court I've ever been in, whether it's on the private side or the municipal or government side. If you're going to present something, then you want to use photographs that present the fact that you are trying to relay, right? So if you took pictures of the entire site and the house next door and all that, and you didn't need any of that, why are you taking pictures of it? You know what I mean? If you're out there for an issue, take photographs to support the facts of what happened to that issue. Does that make sense? So if you're dealing with a tree as an arborist, you want to take pictures of the ground. You want to take pictures of the trunk, the limbs, the top, whatever's left. If only stumps are left when you get out there and you've been asked to figure out, you know, what condition was this tree in, you're going to, like she said, you're going to do a lot of research. Then your documentation is going to be probably electronic, right? You're going back on Google imagery, or maybe the client had previous photos of the tree, that kind of thing. Your handmade notes, we're all really good about note taking, right? But you really have to think, if you're going to ever be in a municipal or government entity situation, or you are going to have to present something in court as a certified or professional witness, watch your notes. Don't write, boy, this guy's an idiot, right? Because those notes become admissible. You know, how does that make you look as a professional? Not very professional. So that's what I'm saying. Keep everything you write, you say about the facts of the case. That's what a good presenter, a good witness does, right? Whether you're for the prosecution or for the defense, doesn't matter. Facts are what matter. So again, your written report should reflect the facts that you are seeing, not something you're surmising, not something I'm thinking happened. If you don't know, you can't say. So it's that simple. All right. And then whatever evidence you've gathered becomes stuff that you have to watch where it goes. You don't want somebody else picking up your photographs that you've already dated and written your dates on or whatever, or put the date into the system. You want those locked so that nobody can go in and change it, right? Nobody can go in and alter it. Back in the day when I first started doing this, everybody had Polaroids. Remember those? Right? You'd wait for it to develop. There were no digitals. And we'd have to write literally with a Sharpie the date and time and who took the photo. And that's who presented in court. Because if you didn't take a photo and you weren't there, how are you going to present that? That could have been anybody's lot, you know, anybody's trees, anybody's anything, right? So you want to make sure that you keep your chain of custody. Make sure you know where it's stored, that it's locked up until the case is presented, right? Have your photos printed out. Don't bring an iPad to court. I've seen people do that. You know, well, here's what, you know, because there's all kinds of things that you can do with iPads and modulation and do these picture upgrades and yada, yada, yada. So print out your photographs, unscrewed up photographs, right? And that's what you're going to use. Write your date, write when you took it, all that kind of stuff. I kind of like carrying an old style camera that I can actually make that kind of note on. I know it sounds cheeky, but hey, it's what it is, you know. It keeps evidence good. And that's pretty much, don't rely on using your camera to display. There's nothing worse than walking up to a judge and say, Your Honor, you see, can you see what, wait a minute, let me go up. Can you see what, you know, the judges don't like that either. So, you know, like I said, be professional. That's the whole thing on that. And we have a form as ISA arborists that we all can use the same way. That gives the same information. That's the tract form if you've taken tract, right? If you don't, there are also other good forms out there that you can utilize as well that are used in many of the industry arboriculture things. So some really good ones out from universities. And I don't want to pick one university over the other, but they're out there. So do your homework, do your research, keep track of your stuff.
And we've got special notes on deletion with pictures and also with handmade notes. Just as y'all know, technology changes constantly, but any lawyer worth their salt is going to make a discovery request of your side, and they're gonna ask for all the notes that you ever made that are still existing, and all the pictures that you ever took, whether they're the ones that you're using in court or not. So if you've got them and they're on your phone, they are subpoenaable, they are discoverable. When you delete them, you know they don't really, they like sit in that whole category for 30 days or whatever, well, they're still on there. And even when you delete them, they're still sometimes sitting in the cloud. And then, you know, if you posted them anywhere, they're never going away. So think about the documentation that you're creating and what you're gonna do with it. And think that every single picture that you take or every handwritten note that you take may have to be turned over to the other side. So like Kay says, don't take notes that, you know, you don't want somebody else reading later. You don't know that that's gonna happen, but you
You
have to
never
make
know.
a decision. Are you going to delete all this stuff or are you going to keep it? And there's no right or wrong decision. It's just whatever you decide, do it thoroughly. And know that you may get a request that says everything you have, whether it's been deleted or not, you know, they'll search the cloud. They'll ask you to do that, so you have to do that.
So what are the enforcement tools? Most municipalities, government entities have court summons, citations, tickets. It just depends on how they write, you know, what they're going to call their enforcement tool for that. You have stop work orders that are posted on sites for that have building permits and things like that. That's an automatic shutdown of everything on the job, unless it's erosion control problems. They are allowed to do erosion control work because we want to stop the mud from going in the state waters, right? Or if there's a safety issue, for example, somebody had a really steep driveway, they were trying to get up, they had it gravel, you had a bad wash, they didn't have their fabric under there like they were supposed to, and it all ended up in the road. Now we have a public safety issue. If you've ever seen cars or motorcycles spin out on gravel, it's not pretty. So those kind of things are allowed to be done. Anything to make the public safe and to keep the mud from going in the state waters. So that's what they use those stop work orders for. You can also use them if your ordinance allows it and writes it, that you can stop a site for improperly impacting or cutting down trees. It depends on how the ordinance is written. And then you can have also court summons for trees illegally removed or impacted without permit. Most municipalities nowadays, a lot of the counties have ordinances that write that, you know, you have to have a permit before you take out a tree. It has to be approved. So if you do that without that, then you open yourself up for these legal remedies, which may be court summons or whatever. And as a municipal arborist or a government entity arborist, you may end up having to write those court summons if you're sworn in. Not every jurisdiction swears in their arborist. Some jurisdictions have ordinances that are issued and enforced by police, by code enforcement. So shoot, one of the, I think it was Woodstock, back in like 2005 or 6, had their sheriffs were the ones that enforced ordinances. So if there was a tree violation and they were out cutting something they didn't have permit for, they would show up with their guns on, you know, and take you away. So I'm like, okay, not me, but you know, that's how some of them are set up. So you really have to check with the jurisdiction you're in. Injunctive abatement is another one. And we'll get into that in just a second on the next slide. And then the final thing that they can do on a construction site for an enforcement entity is revocation of permit. So a lot of them have a 3 strikes, you're out kind of thing. You get 3 guilties in court, they can have the ability to not issue you a permit from there on out. So if you're a builder or developer, that's not something you really want to do. So, all right. So this is the advanced enforcement, like I said, is the injunctive abatement. It's basically a court-ordered injunctive relief known as an injunction. It's a remedy that's sought in a civil lawsuit in addition to or in place of monetary damages. So rather than offering money as a payment for a wrong in a civil action, injunctive relief is a court order for the defendant to stop a specific act or behavior. Okay, so a court will order that. Those are usually done in, you know, private cases. Let's see, the revocation of a permit, like I talked about, it's usually for repeat offenders. after guilty finding in court. And it's not in every ordinance. You have to look at the ordinance for the jurisdiction you're in, not to repeat myself, but I think I'm repeating. Just like I say in the classes, if we're telling you something 2 or 3 times, it's something you really want to look at. Okay, now this is a fun one. How do they serve court citations or summons or tickets? Just in case you were thinking of going into the world of government enforcement for trees or whatever, erosion controls. When you go to deliver a citation, or let's call it a ticket for this case, you literally are asking, if she was the one I was citing, I would say, you are Lee Clark of this address?
Maybe.
Okay.
She's not home.
Or she's not on the slide. Come on. We don't usually get that. But anyway, you introduce yourself and say, Gloria, and say, hi, unfortunately, I'm having an issue with citation for this issue. You will get to say, anything you need to say in court about what happened. And I would like to give you a copy of the citations on this date, this time. The address for court is right here. And all you have to do is signing the court summons is not an admission of guilt or innocence. It's really saying to get your copy of the citation. And she has the right to say no.
Yeah.
Right? And you say, that's fine. You don't have to sign it. And you write on there, personal service and the date. And then you say, okay, so you don't have to sign it. Here's your copy of the citation. She can still sign it. Okay, that's fine too. All right, I totally understand. But here's your citation. You drop it on the ground at their feet and say, you've been served. If you fail to appear, a warrant may issue for your arrest. That's the way it goes in court. And if you have any questions, here's my card. Please call me. Whatever name's on there, my number's on there. This is the jurisdiction I work for. That's all on there. So it's whatever information you have been instructed to give by your enforcement entity. Okay. And so that's kind of how it goes. And I've had this dialogue, and I've had that guy by the end of it say, thank you so much. I realize I goofed and I just wasn't thinking whatever, and they'll take the citation, but I've had guys too that hit it at me all the way down the driveway over my years doing this, so it can go lots of different ways, but we're all there to do a job. That's the bottom line. So we try to be nice, we try to be civil. I'm not familiar with enforcers or people that work for governments that I've had experience with who are ill-tempered. Now, I'm not going to say there aren't any. I'm sure there are. We've all seen the stuff about police officers or, code enforcement people that seem mean and all that. Could be they're just having a bad day, just like everybody else. But anyway, these are the issues that we go over as enforcers of an ordinance or code or state law, things like that.
And then all those things that you do to serve that, you're going to be asked to testify about that in court.
Right. She can say, I never got that ticket. I didn't sign for it. You're right. And that's why I refused to sign. This time, this date. Well, I didn't take the ticket. Did I drop it on your feet in front of you? Yes. Again, you're testifying to the facts, and that's what they need to understand. It's nothing personal. This is just how we do our jobs, right? All right. So who can do this stuff? Who would present the case in court in a government entity situation? It could be the city arborist. It could be a forester. It could be a warden, if they're sworn in by their jurisdiction. Okay, not all of them are. The code enforcement officer, and you are then subpoenaed as a witness. Okay, if they do it, or the police officer does it instead of whoever's, like the arborist, the forester, or the warden's not empowered to write a ticket, then you would go with code enforcement officer. They would subpoena you as a witness for what the violation was. They would issue the person who did the violation a court summons, and then it would go to court, and the same thing would play out again, right? Or it could be from a city attorney, and then you would be the witness for the city attorney's prosecution. It could also be,
if it's private, then it will be the plaintiff's attorney is going to be presenting in court, proving the case. They have to prove it by preponderance of the evidence if it's just a normal suit.
okay. Like we were talking about, you're going to present the what? The facts, right? This is, again, on such and such date at such and such time, I saw, I witnessed, I found. Those are facts, right? Present your evidence. Here are the photos I took on this date at that time of what I am saying I found. I always like to remind people to number their photos. If I'm working for the plaintiff, then it would be the plaintiff's 1, 2, 3, 4, 5, so P1, P2, P3. And that's how they get introduced into the court, and that's how they're accepted by the court. Maybe you're doing it for the defendant, and it'd be D1, D2, D3, D4, defense, right? Only answer questions you're asked. That's usually a good rule of thumb. If they ask you, did you see Mr. Jones cut down this tree? Yes, I did, or no, I didn't. Okay, then it goes to the next question, right? What evidence do you have? And that's where you start presenting your evidence, what you have. If you have been established as a professional witness, at that point, you can state, in my professional opinion, as a certified arborist, I believe this, you know, I saw this, and that's what I interpret that to be as my professional opinion. Terms to avoid if you're not doing professional opinion, I felt. That's not a fact. That's how you feel. Okay. I thought. I thought about it. It could be it. It seemed to me they must have been guilty. That's not a fact. I guess. That's the last thing you want to say in court. Okay. You are there to present facts, whether you're a professional expert witness or a fact witness. You're there to present facts. You can do your opinion if you're a professional witness about trees or about whatever it is that you've been hired to be a professional witness
So
about.
if you are just a fact witness and not an expert witness, the difference in your testimony, fact witnesses are, I mean, we don't call them fact witnesses, they're just not expert witnesses, they're witnesses. And they will be asked about the conditions that they saw, things that are observed with their 5 senses, what they saw, what they smelled, heard, touched, all of those questions. The expert witness is the one who can join it up. Yes, I observed this. It's the 5 senses questions. I observed all this. I found this. I saw this. I took pictures. I formed this opinion. And that opinion is like the linkage of here's the facts. Here's the conclusion we want the jury to come to of the tree should have been cut down and it was unreasonable that it was not tended to before it fell. And so you make that connection of you take it from the facts to the conclusion. Normally that is the jury's providence. That's something that witnesses can't do. They just testify as to the facts, but then the jury connects it up. But when there's an expert witness, the expert witness can step into that role and do the connection for them. That's why it's not everybody can be qualified as an expert witness. It's up to the judge to get qualified. The side that you're on will present all of your credentials to the judge, and the other side has an opportunity to object to those. They take your deposition. They usually don't object because attorneys don't pick experts that aren't really expert. And there's not a lot of, well, anyway, there are the tree case experts that we know of that are the ones that we call. And so this leads into, there are different questions depending on the setting that you're in. If you're in a deposition, that is the other side that's trying to find out about you. And since you're going to be an expert witness, they're asking you questions about your background and your credentials and all your experience and everything about you that they could possibly know. And then they start getting into what is your opinion? How did you document it? How did you form your opinion? Then these are friendly questions. They're just trying to find it. They're just trying to gather information. They are going to use that information against you though. But when they gather it, they're being pretty friendly. It's open-ended questions, and you're sitting in a conference room or like at the court reporter's office, they have a conference room where it's an attorney's conference room where it's somewhere not high pressure. You're not in a courtroom. There's no judge there. And if they have a dispute that they can't agree with during the deposition, they just put it on hold and they do a motion to the judge later. So there's never going to be any hashing out of anything. So those are friendly questions. They're just open-ended, gathering information. The next step is when you get to trial, you're going to have questions on 2 different sides. One is direct, and that is your side is just asking you to explain about what did you see? How did you form your opinion? Show us your pictures, show us your report. And they go through that. The other side asking you questions, trying to attack you, that's cross-exam. And the style of questions are very different. On direct, so that's your side, they're just trying to get your story out. They're gonna, again, ask like deposition questions. Just tell us what you saw, open-ended things. But then the other side comes up and they're gonna cross-examine you. And cross-examination, you ask leading questions. You only want yes or no answers because you are leading someone. You are,
Trying to
you know,
get them
we've
to
all had these fights with spouses and we know what leading questions are and we know how to do this. That's what lawyers do. It is called for on cross-examination. You only ask questions that have a yes or no answer. So you did this last night, didn't you? Yes. You know, instead of what did you do last night, it's you did that, didn't you? And so it's yes or no, and it leads you where they want you to go. It's very easy to just get complacent and follow where they're taking you, but don't do that. As Kay says, only answer the question that's asked. Don't elaborate because just don't elaborate. It's not going to go well if you do. And they will use it it'll come back to bite you.
Yeah, they'll twist your words. I mean, there's all kinds of things that can happen with being on cross. It's okay to ask them to repeat or rephrase a question. If you didn't exactly understand what they were saying, it's okay to say, can you ask that again, or can you rephrase that? I'm not sure what you want me to answer. I mean, just be honest, you know, we're people, you know, and it's okay to say you don't know if you don't know. You know, well, were you there? Did you see the guy cut the tree himself? No, that's okay to say that if you weren't there, you know. Do you know if they used a chainsaw from Vermeer that they bought, or did they use one from some other company? I don't know. You know, it's okay to say that, you know.
And it's better than yes.
Yes, don't guess. That can just get you in all kinds of trouble.
Get harmed by guessing.
And one thing that I, you know, at the academy when I was there that really struck with me and it really helped a lot, firstly, in the first state court case I had to go to, was to breathe before each answer. You get so nervous. I mean, like we get nervous up here giving presentations, but when you're in a courtroom with this kind of stuff going on and people looking at you and, you know, you got mics everywhere. I mean, just breathe and relax. Just be yourself and just answer the questions honestly. Present your facts. That's it. You know?
And when you're in deposition, the friendly kind of questioning, it's all being recorded. And it's up to the other side how they want to record it. Sometimes the court reporter sits in the room and takes it all down in their court reporter machine, and it prints out into a transcript that you then have a right to read and correct, but not change. You can correct it like there's never any corrections because it's all a machine. So you can't change your answers. And then the other side is going to have that deposition printed out in front of them at trial. So if you say something on the stand that is different than what you said at deposition, the lawyer, if they know what's going on, they're going to stand up and make a deal out of it. And your credibility will be questioned. You're not going to look so great on the stand if you're not saying the same thing that you said before. And if they, on the stand, the other side certainly will ask you about your report, like, why did you put this in the report? Or what does this mean in the report? If you don't remember your report and it's not in front of you, you don't start guessing. You ask to see the report and they've got to hand it to you and you can read it there on the stand. Or they'll say, when was the last time that you read the report? And hopefully you'll say right before I walked in here, you know, to refresh my memory. Just to have some answer to it. But if you don't remember, you have a right to just ask for it. If they leading cross-examination is a gotcha. They're trying to get you. But on your side, the direct, they're not trying to get you. They're just trying to get your story out. They're trying to get your opinion out. But you have to be really careful on cross. Don't let yourself be led. They're leading you where they want to take you, and it's not necessarily where you want to go.
That's why it's important to remember the facts, just the facts. That's it. That's all that it's about. You know, why you wrote the citation, why you went out when the client called, why you decided to make this course of action on the tree. Those are the facts. You're giving the facts. It's the safest thing you can do, really, is stick with your facts. You know, what can you prove? What can you not prove? You know?
So hopefully we have communicated to you about who sues who in one of these cases, whether it's municipal or private. See, didn't do that again. who is getting a ticket or issuing a ticket? Who hired you? Who do you want to hire you? Yes, lawyer, thank you. And what are you hired to do? Well, you put that scope of work in your contract and then you adhere to it. Don't be doing things that aren't called for or that they don't hire you to do and then expect payment for it. That's not necessarily gonna happen.
And if you're a municipal arborist or a government entity arborist, again, what are you being hired to do? Are you going to be expected to be sworn in and have to present cases in court? Are you just hired to check park trees? You know, really know what it is you're being hired for. And that can help you decide if that's something you wish to do or you don't want to do, you know? Just, yeah.
And then we told you about documentation. There's no right or wrong answer on whether you keep your notes or destroy them, but whatever you do, be consistent about it and just realize that everything that you produce as you are forming this opinion is discoverable by the other side. They can ask for it in a summons and get it. And if you say there's none and there really is some, that's a problem. So don't put yourself in that situation. So know what you have, know what's deleted, know what you want to use, and just have it secure in one file and don't mix it up with other things, you know, just keep it all straight. And then we told you about the different kinds of, enforcement.
Yep.
And then the different kinds of testimony. Deposition testimony is just going to be friendly. Direct is going to be open-ended, tell your story, what's your opinion, and then cross is gotcha. So different ways to handle each of those questions.
But remember, even in deposition, when it's friendly, stick to the facts. You know, because they'll want you to say additional things. They'll try and make you feel like, oh, I'm great, you know, and I can tell you anything. Stick to the facts of what you're being asked to present about. That's it.
You know, they're going to try to pull you off and they're going to try to get you to expound about things. And they're doing this not because they're chit-chatting and they like you and they just want to chat with you. They're doing it because the more they can get down in that testimony that's going to be transcribed, then the more that you may contradict yourself on the stand. So just watch your words and definitely read through the deposition after it's printed out and transcribed, and then read it right before you go in again, and also refresh your memory with your report before you go in to testify too.
Yep.
Okay.
Any questions?
We do have a question from our virtual audience. The first question, somebody asked, you mentioned the academy. I assume that you're referring
Police
to
Academy, DeKalb County.
Oh,
Yeah.
the Police Academy.
Yeah.
Okay, I was wrong. I assumed that you meant the ASCA Consulting Academy.
No, but that's on my list.
Okay, so, and the reason I assume that is because at the, if you're not familiar with ASCA, it's the American Society of Consulting Arborists, very different organization, very different mission from the ISA, but they also provide training for arborists. The Consulting Academy has a whole day on this topic of being an expert witness. And so they teach you, you know, some of these basics on how to be an expert witness and about, you know, what's discoverable and that sort of thing. So just throwing that out there. If you are a consulting arborist or considering that, or you think you might be an expert witness, maybe something to explore.
It's always good.
Resources. They've got a sample contract you can use. They've got, just all kinds of, it's an expensive membership, but boy, if you're going to do this, it's a great.
It is.
resource.
And it's an expensive consulting academy. They only do it once a year. This next one will be in 2026. And it's actually going to be on the East Coast for the first time in a long time. So if you're thinking about attending, I would recommend going this next session. I think they usually hold it in February, so something to consider. Would you go over expert report and the expert's declaration or affirmation?
So I guess that's when you're becoming an expert witness.
It just says expert report and the expert's declaration or expert report and expert's declaration or affirmation. This was kind of early in the presentation.
I'm not familiar with that terminology. I don't know if that's something that's for a specific.
Is that different than the written report?
George, if you could elaborate on that, that would be.
Yeah, that would help.
We'll go to the next question while we to discover more about that. What is discoverable? All notes and photos from all work ever, or only the matter at issue?
Well, the other side will try to discover as much as they possibly can. So they're gonna ask for everything. And then the attorney on your side is gonna try to tamp that down and get them to say, no, you don't need everything. Let's just do this. And they'll come to either an agreement or it'll end up going to the judge and the judge will have to decide the scope of what you have to produce. That's unlikely. You're gonna come to an agreement. The two attorneys will come to an agreement, most likely. But be careful. Any pictures you take, any reports, any handwritten notes, it could potentially all be discoverable. So be careful in everything that you prepare. Unless you know you're gonna shred it.
I got that one for you, Jesse. The question, it goes at the end of the report, your declarations and affirmations. I certify I am this. It should be about 10 parts. Underneath that, you have your limitations and liability agreements. There's two different parts. One of them is I am awesome and these are the reasons why. The second one is I may not be awesome and these are the reasons why.
Is that in a specific court, state of Georgia?
Every report. So anytime I see another arborist report and they're dabbling in consulting, that's always missing. Those are the parts that protect you from your report. The biggest problem in my meeting earlier today was this same concept of when you release your report, you're no longer in control, which means that you didn't put your affirmations and the other components and your protections. Who uses your report after that could be totally whatever they want. The malfeasance that comes from that and how a lawyer interprets that, that protects you even, that says, my report was used incorrectly. I retract myself or my report. That's your get out of badness from being used against you. That is, if you are used unethically to cause harm to others, which does happen, by a lawyer stating, my client said that these trees are worth $25. We want $700,000. That's a legitimate case. That kind of craziness. It would allow you that if you knew that that had been used to go, wait a second, I, as an ethical arborist, do not agree with that. In my contract, according to those affirmations I put in there, that if this is used incorrectly or against my wishes, I then remove said document.
I get it. It's like a liability waiver and
It's all-
exemption. Most of,
It's a great resource.
exactly. So it's a great training resource. I know for municipalities that I've worked for and government entities, they always have those disclaimers at the end of our emails and most of our paperwork. So sorry, I didn't know that's what they're,
So,
I didn't know there was a specific term for that. So
what's happening literally is we have so much information that's available that we think that no one is going to use that to harm, or it's not going to harm us. So people in their learning stages, I was there, anybody that's ever written a report starts there. We make mistakes. The problem is that now lawyers are really, really good at exploiting your mistakes against you or against your client or against however they want to, because legitimately that whole thing earlier was, so we think that we're doing something great. They have literally from 1778 or 1787, 1791, the Constitution from there all the way up to now to really go, oh, well, you thought that, but here's the full letter of the law, and we won by default. So that's why earlier, that's where we're dealing at. We are no longer dealing with utopian society issues. We're dealing with the letter of the law.
All right, we have some other questions that, from our virtual audience. Does somebody in the live audience want to ask a question before I move on to the virtual questions? What is the advantage of tree risk assessment qualification when doing expert or being an expert witness?
It adds to your qualifications.
It
I mean,
does.
everything that you have that demonstrates that you have attained some standardized,
training.
yeah, some standardized level of achievement. It's a certification test. You have achieved this. Yeah, that just goes more to your credibility.
It goes to you
Yeah.
being more of a professional than the average person on the street. So
Yeah.
you're building your credentials in layers.
And it doesn't mean that you can't be qualified as an expert if you're not tracked.
Right.
But, it depends on the situation and the judge and the situation, basically.
Earlier, chatting with David about reports, and this exactly came up. Sometimes as an arborist, make sure you overbuild your report. Two, if it says it is a class 2 or level 2 assessment, do it. Do not fake it. You will have to use that later on. Make sure that you prepare your report with enough information that you 100 days from now, we'll be able to review that and actually.
And know
do
what you did.
Level 2 review in a court level scenario.
Yeah, good,
Yeah.
good report keeping and good report writing. Yeah.
Definitely.
Be accurate. Yeah.
Just remember that your notes are discoverable. So
Yeah.
if you're writing a track report and you don't want your notes to be, included, then destroy those.
And don't write your notes on that form.
In the
Yes.
world of liability, the track part is a really big help for you as a professional, because it helps take something that is subjective and put some objective source to it.
Right.
The track is a phenomenal tool.
Personal question, Kay, is it typical for a city arborist to go to state police academy?
So it wasn't state, it was county, and that was back when I worked for DeKalb County. Years ago in my youth, when I was 18, I was employed as a animal control officer and made my way up to master officer and criminal investigator for oh heck, I tried to put all out of that out of my mind, sorry, for cruelty cases. So from there, I went back to my first love, which was, code enforcement and trees, and did code enforcement. It was during that period in code enforcement, they sent us to the police academy for investigations training, for evidence handling, for court testimony, how to present tickets. I mean, it was a full 2-day course. So it really helped me a lot in my career. Not everybody gets to do that, but I got a different look at things. I also went to investigation school, which covered that too, and that was a week long. Really good at University of Missouri. So I've been around a while. Been doing trees. I've loved trees most of my life. I worked at a tree farm when I was younger. Anyway, but yeah, so you learn all this stuff and it gives you all this knowledge, and then things you can use, and it just helps in what you do in life, so to keep all your stuff together and learn as much as you can.
Do you have to be local in order to be an expert witness?
No, not at all. No,
Mm.
no.
100%.
Is this a question
No,
or?
state of Georgia Constitution has tree parts.
Sure, forestry, it covers that. It covers all kinds of stuff.
That's the thing. Outside of this state, gigantic discrepancies. It goes all the way to the Constitution. That's why earlier I was saying this law issue in trees, that's our first laws for trees. So whenever someone from North Carolina meddles in tree law in Georgia, that's a gigantic difference, even per state.
Yep, different laws, different states. You need to know the jurisdiction you're working in. And that would be for, whatever case, but, even knowing your trees, we all know the mechanics of trees. But if me as a southern arborist goes up to, I don't know, somewhere up in the tundra, and I'm dealing with different species of trees, I know how they function, but I may not know the specific diseases, the specific needs that that particular tree in that region needs. So if you're going to go do something like that, you're going to speak to generalizations, but most attorneys that are looking for an expert witness are not going to pick somebody that's not from where they're practicing at. So it's just been my rule of experience anyway.
But there are people like Dr. Coder. that-
Oh, sure, they could go anywhere and tell you anything.
Anywhere.
Dr.
So
Gilman.
it depends on,
Yeah.
yeah.
Any questions?
My favorite question that they ask in depositions is, have you been arrested?
That's always one.
Always.
Yep, always.
And I always say, not yet.
I'm sure that always helps. Break the tension. Yeah. Okay.
Well, thank you.
Oh, and there's our email and, our numbers. If you have any additional questions or you want any additional information, please feel free to reach out to us and we'll try and help you out and work you into our busy schedules. So,
Logan would like to say something. Logan is the
Oh.
board president.
yes, Logan, come on up, say something.
I'm just gonna say, Jesse has printed these flyers for us to hand out to people, encourage them to join the GAA. We have a staff event, please come get some, and if you see folks working in your area, please pass them out. We want as many people to get these resources as we can for our membership. And it's just a quick little 1-page flyer on some of the benefits, and then after please grab them.
There's also flyers on the insurance information. As a member, you should have received an email recently from me going over all of this information, but there's,
we've received notification and been working with the Georgia Forestry Commission about homeowners being canceled if they don't follow the guidelines of their insurance company. So insurance companies are sending out drones and LiDAR and saying you need to prune this limb or else we'll drop you, or you need to remove this tree or we'll drop you. So we're trying to come up with a collective way for the arborist community to fight back against the insurance, not the agents, but the underwriters, thank you, words are hard, against the underwriters in this issue and have a collective voice in the matter. And so we've developed some tools and resources for arborists to work with homeowners on this. So I have printed out some flyers back there with all of the resources that we've gathered. So feel free to take some of those if you want to give them to your clients if they're dealing with it, or if you just want the information for yourself. There's lots of online resources. We also have a separate letter for municipal arborists to use that they can customize to use with their code, their specific code. So hopefully if we have a collective effort toward this issue, we can, you know, perhaps save some homeowners from having to deal with this and remove trees unnecessarily. So if you have questions, happy to answer that. I'm going to get the CU code for you guys, and I'll drop that in the chat for our online visitors. Thank you all again for joining us. I'll be sticking around cleaning up for a little while if you have any questions, comments, concerns. Also, Maria is here, who is our Spanish outreach coordinator, so make sure you say hello to Maria as well. Thank you all. I don't think so. I did not see one.
No, I didn't, I looked through it.
I'm sorry, this is gonna take me just a second to get this code to you guys. I'm working on it though.
She's.
Okay, we're good. We're getting there. Okay, there is the code for CUs. And I'll stay on for just a minute longer.